All right, guys, we're going to go ahead and get started. Just welcome everyone to our first B2B best practice of the year. This topic's on trademark and copyright basics for business professionals. I'm Erin Hiles. I'm the Director of Programs and Events for Barron County Chamber of Commerce, and I'm very excited to see you all today. Before we dive in and officially get started, I do want to go over some housekeeping rules with everyone. First, this meeting is being recorded, so please keep your mics on mute for the duration of the presentation. Second, we will have a Q&A portion at the end. I'm going to go ahead and submit an example in our chat box. I do think the meeting, we have a good crowd here, about 7, so we may not use the chat box. Just feel free to speak up when we do get to that Q&A portion. So we're going to go ahead and get started. I am going to introduce Laura Hagan. Laura is an attorney practicing with the firm of Carrick Backert, PSC. They have offices in Bowling Green, Glasgow, and Elizabethtown. She was born and raised in New Haven, Kentucky, and attended the University of Kentucky, receiving a Bachelor of Health Science in 1987 and a Juris Doctor in 1993. She is registered to practice before the U.S. Patent and Trademark Office, and her practice consists of assisting companies and individuals with their intellectual property needs, such as patents, trademarks, trade secrets, and copyrights. Her services include preparing and prosecuting applications for registration, drafting agreements for transfer, and handling disputes involving infringement for various types of intellectual property. Laura currently serves as the chair of the Western Kentucky University Research Center, and she is a member of the governance committee for the board of directors for Feeding America Kentucky Heartland. In the past, she has served in several leadership positions for various boards and nonprofits, including Community Foundation of Southern Kentucky, Bowling Green St. Vincent's de Paul Thrift Store, and the local chapter of American Red Cross. Carrick Backert PSC represents clients in state and federal courts throughout Kentucky and offers a wide range of legal services. In addition to intellectual property services, Carrick Backert provides a wide range of business-related services, including organization and preparation of corporate documents, contract preparation and review, real estate and business litigation services. Superior client service is what Carrick Backert strives for, providing creative, practical solutions and proven results. Laura, we are so excited to have you here today. I'm going to hand the floor over to you.
All right, thank you, Erin. Good morning to everyone. I guess it's lunchtime now. Good afternoon. I'm so glad to see all of you guys here today and a few faces that I recognize. So we'll just dive right in. I'm going to have a PowerPoint presentation to share. So I'm going to see if we can get that on the screen right now.
It is showing up.
All right. Very good. So since we do have so few, if anyone does have questions, I'm fine if you want to stop me, because you think of it while you're going through the content and you're scared you won't remember the exact question. So just feel free to either send a chat and Erin will let me know, or we will just turn your mic on and we'll get going. So we're going to talk about trademarks and copyright today. We're going to start with trademarks or service marks. So a trademark or a service mark, a trademark refers to a good, such as computers, Nike tennis shoes, Coca-Cola, sodas, where a service mark refers to, service that's being provided. So Western Kentucky University provides educational services. McDonald's is a food service, and they also have products too. That they have trademark registrations for. So you see that TM, that means a trademark. You're talking about good. SM refers to a service mark. There are different ways to kind of acquire your trademark rights and ways to enhance them, really. So we're going to start with common law. So if you provide a good or service, or you sell a good that has your name on it, then you are establishing common law rights where you've used the mark. And so that's where you've had sales. If you're located in Glasgow and you have sales in Bowling Green and Elizabethtown, Hart County, and maybe in Louisville and Nashville, Then you've thinking about a map. If you have a dauber, just where you've had those sales, you have those rights in that area. Uh, and you can use a little SM or TM um, with those marks to identify that you're aware of your common law rights. You're claiming them. You don't have to apply to get those or register your mark anywhere to use that notation. And I think it provides value to the business because people appreciate that and sometimes are a little less likely to actually just copy your mark if you've got that notation. State registrations are available in Kentucky. Uh, State registration does not provide you with the entire state like you think it would. It really just solidifies your common law rights. It gets noticed. People can search that database and look and see that you have that registration. I rarely recommend a state registration, but it can provide, it's a valuable tool in some situations. What a lot of people hear of is the federal registrations. And with that, you apply to the U.S. Trademark Office to ask them to register your mark. You file an application to do so. That application date is constructive notice to anyone in the U.S. that you're using that mark. So that federal registration enhances your rights and lets you claim in areas really where you haven't even used it yet. Where with the common law rights, it's just where you've used it. You may have used it in the state of Kentucky and Tennessee, but you don't have any rights in Colorado and you couldn't enforce that against anyone. But with the federal registration, if you ever go out to that area, it can allow you to send a cease and desist, stop using a mark to someone who started using subsequent to your filing date. So again, that filing date's very important. And it allows you more nationwide protection. Almost all franchises have federal registrations, and that's a lot of time what that franchise is really based on, the right to use that mark and the comfort in knowing that you're going to be able to stop any users that might have similar marks. So the R in the circle is a federal registration. My slide shows a little O. Google has obtained a registration. Since I kind of copied this off Google, they actually have registered mark too, and they actually should have been using an SM instead of TM, but I think they've moved forward a little bit and taken steps to register. But those are the notations that you see. You know, the R in the circle means you've applied to the trademark office to get a federal registration. And the TM just means you're claiming your common law rights. So just kind of to summarize that, you know, common law, no filings required. You can use the TM or SM designation, but it only provides rights where you've used that mark. And with your state registrations, the cost is very inexpensive, $10 per class of goods. And both the state and the federal trademark offices break down all goods and all services into about 48 classes. So they kind of categorize whatever your good or service is. And if you are using it for two different products, maybe you sell tennis shoes and you also sell bikes, those are probably going to fall in two different classifications and you'll have to pay a filing fee per classification. So all those forms are available in the Secretary of State's business website. I've provided that link there. You can search marks. And it really, again, just solidifies your common law use. The federal registration, of course, you go to the uspto.gov. I've got that link there. It's all done electronically now. The filing fees have increased since I prepared this slide. They're up to $350 per class now. And they're also charging additional fees if they have to modify your goods or services. So it's gone up quite a bit just recently, actually. When you file your application for federal registration, it goes to an examining attorney who reviews the database to see if there's anything similar registered or pending for a similar good or service. And so if they don't find anything, they may approve your application and you'll get that registration. If they do, you'll have an opportunity to dispute that, maybe argue your case by you shouldn't be receiving a refusal and have a chance to convince the examining attorney otherwise. But every application that is filed is not granted. But I tell people if they come to me as an attorney to file their application, they're going to spend between, to perform cursory search, meet, try to identify your goods and services, file the application and the filing fee, about $3,000. And that's not a flat fee, but that's a good estimate. All right. So this slide is really just to kind of let you know that all marks are not created equally. They, trademarks go along a spectrum of goods, of strength. And so down here, you have generic marks that really are not subject to protection. They might be completely descriptive marks, such as, if it's geographically descriptive or it's descriptive of your goods. Um, Bowling Green, Kentucky restaurant would be a terrible name for a restaurant, but it would be generic because it's geographically descriptive, Bowling Green, and it is also descriptive of the service that's being provided. So those marks, while some people really like to use them, especially when your product is one that's being Googled, um, they're great to help drive customers to your location, but they're just not protectable, meaning you can use them, but so can anyone else. So you're not getting very strong trademark protection when you use those descriptive marks or generic marks. Down the line are kind of descriptive. They're generally not protectable except in certain circumstances. I mean, American Airlines is one that has gained protection only because they used it for so long. Exclusively, no other airlines was using that mark. And so they were able to argue, that they had acquired secondary meaning. People began to understand that American Airlines meant their company. So there are some situations that descriptive marks are protected, but limited. Um, Suggestive marks are a little stronger. They might provide some moderately strong protection, and hence as to the product quality or characteristics. A few, for example, are like copper tone. You get a copper-like tan. It kind of suggests what the good does. Netflix, flicks that are ordered online. Again, it's kind of suggestive, but it's not descriptive. Uh, Chicken of the sea is another one, something similar to poultry that comes from the sea. So those are moderately strong, and at the very end are the arbitrary and fanciful. So arbitrary is where someone might take a well-known term such as Apple and make it a computer. Tide detergent. And then fanciful marks are words that were really creative for the product, like Kodak film, Xerox. I mean, those were marks that no one should really be using unless they're trying to kind of play off the goodwill of that product that had established that name. So infringement, you probably heard that term. Infringement is like trespassing, a trademark, a trademark registration, even common law rights, they are property that can be transferred and sold. And when businesses are transferred and sold, those trademark registrations can be valuable assets that are assigned to the new owner as a result of that transfer. Um, so when you think about infringement, you're thinking about someone stepping on your property. They're infringing. So the test for infringement is it used by the infringer? Is it likely to cause confusion among consumers as to the source of the good or service? So do you go to one website thinking you're at another one, make the purchase or almost make the purchase, and then you're so far in, you go ahead. So there are 13 factors that are considered, but there's really two big ones. How close are the marks, and how close are the goods or services that the marks are in use with? And they slide rule those two. So the closer the goods are together, if you're selling potato chips in one um, for good, and then maybe pretzels or another peanuts or something like that, those are pretty close goods. So the marks would have to be pretty far apart from the other, and vice versa. So just for purposes, so you can kind of get a feel for that. If you were in Walmart, this is an example I give to my clients often. If you're in Walmart and you're in the potato chip aisle and you see uh, Planters, or you see Planters peanuts, and you think, I love Planters, they're a great product. But then you walk down the aisle to the chip section, you see Planters chips, you're probably gonna think, oh, I think Planters must be making this product. They must have expanded their snack selection. I'm gonna give it a try because, I trust that brand maker. So that's a situation where the marks are not identical or the products are not identical, but that would be an infringement. I think a good case of infringement for Planters. However, if you walk through the store, out of the grocery department, through the clothing department, through the auto tire section, and got to the shoe department, then you're a little further away, right? Those goods are not as connected, and a Planter tennis shoe could probably exist together. So you don't, when you get a registered mark, it's only for the goods or service that you're using it on. And so there can be other uses of that mark. Um, Additionally, just want to point out that phonetic equivalents are generally considered the same. So if you're the Quick Mart and you spell it KWIK instead of QUICK, that change of name generally is not enough to alleviate that confusion. The phonetic similarity is very important. Now, there are some examples where even that situation where the goods are the you know the tennis shoes probably would not even be allowed, and that's with famous marks. uh, Famous marks get a little bit more protection. They are subject to a dilution claim. They can argue that your use is diluting their claim, and I have seen in my practice famous marks really do push the envelope on that. They will go after completely unrelated goods or services, people using a similar mark, just because they can. And they're a little bit of a bully in that regard. Um, I had an example. BMW, of course, has several registrations for their logos, different initials, etc. And I had a client that had a hair salon in Lexington, Kentucky, and her last name was Beam, and she used a round circle with scissors, open up, kind of, a rondello with a design element included in it. Nothing exactly like the BMW at all, but she called herself Beamer Salon, and she not only got cease and desist alert, this is very unusual. They actually filed suit against her in federal court without even a notice. So they really, of course, she couldn't fight that. It was going to be, $6,000 to file the response, and she didn't want to invest that money. I mean, that wouldn't even got you anywhere. Now, in my mind, there was no infringement, but it's just a situation where they've got greater resources and really kind of flex their strength in that regard. One case is kind of interesting and was in our area. I don't know if anyone heard about this, probably not, because you guys maybe don't follow trademark law, but Victoria's Secret filed suit against Victor's Secret, which was a lingerie and adult toy store in Elizabethtown in Radcliffe area. And they alleged that this use was diluting Victoria's Secret mark. So in this situation, the goods were very similar, kind of like the peanuts and the potato chips, maybe even a little closer. But the marks were different, right? Victor's and Victoria's, but they certainly are similar. So the Victor's Secret, the Supreme Court, it had been all the way to the Supreme Court, and they actually found that Victoria's Secret had not shown any actual proof of that this use was diluting their mark or harming the reputation of their mark. However, after this case came down, the owners of the famous marks sought legislative change relief, and they enacted a Trademark Dilution Revision Act in 2006, which allowed owners of famous mark to merely show that there's a chance, a likelihood of dilution or blurring or tarnishing. So call to mind does not necessarily equal confusion. And, this is really, like I said, there are 13 factors that have to be looked at. And you can read a lot of cases, and I know people give attorneys a hard time because they often say, well, it depends, but it really does depend on all the factors. You really got to look at, and every situation is different. Here's just another situation where uh, the court really said that, just because it's calling to mind, it is not confusion. And this was the Harvey cartoons lost a trademark and copyright infringement against Columbia Pictures for that Ghostbusters logo. The suit was based on the Fatso character who appeared in those comic books. He's down on the corner there. So for the trademark claim, the court found that there was no significant chance that moviegoers would expect to see a Casper cartoon when they were going to see the Ghostbusters movie. And here are just some generic marks. And if you remember, generic was on the very end of the trademark spectrum. It was the lowest level. And I just wanted to give you some examples of situations where a product started out as a trademark, but it just got so popular. Everybody started using that name to refer to other people's products for a similar product. For example, and if that happens, it just becomes so overused, um, it can actually, you can lose your trademark rights. So kerosene used to be a trademark, cornflakes, cube steak, escalator, trampoline, raisin bran. So some of those linoleum are started out as trademarks, but after a while, people started using that trademark to even other people's products, and uh, it just became so used by consumers that the trademark rights didn't really serve as a trademark anymore. It wasn't distinguishing one manufacturer from the others. And so it's very important when you use your trademark, it is an adjective, not a noun. So you should say Kleenex tissues, and you might see that. I know Kleenex has rescued their mark from becoming generic because everyone, used to really use Kleenex uh, almost as a generic mark. It didn't matter where the tissue came from, you called it a Kleenex. And so you'll see that trademark owners are very careful to kind of use it as an adjective, not as a noun. You're not really, it's the Kleenex tissues, so it would be cornflake cereal if that was the case. There are some bars to registrations: immoral, deceptive, scandalous, disparaging marks. So uh, the immoral and scandalous, I'm on the trademark database just about every day, and I think that's boundaries being pushed and what's kind of relative to what society finds acceptable these days versus maybe what it did 15, 20 years ago. Deceptive, that means if you call your product a California wine, and that's just a generic name and descriptive, but you can't use California if the product's not produced from there. So they won't let you even register if you have a deceptive term in your mark. Disparaging the Redskin, and there's a couple of cases where they canceled the Washington Redskins mark for the national football team, or I think there was football, or it may have been baseball, and then even refused to register Washington Redskin potatoes. So those are some situations or some marks that you might not be able to get a registration on. Again, it doesn't mean you can't use them. You just might not be able to get that federal registration. So a little bit of practical advice for business owners is, before you settle on a name for your product or your company, um, you should check the USPTO.gov database. There's a very good and user-friendly search engine where you can put that term in, see what is registered, because I've had so many people in my office over the last 30 years of practice where they get their name set, they maybe 5 years in, um, and then they'll get a cease and desist letter because someone has a federal registration and maybe they're moving into the area. And so they actually have to stop using that mark. Um, so very good to avoid that heartache and expense is to get on the database and conduct a cursory search. Um, you might not be able to make that call. I mean, obviously, if you pull up a registration for the exact good or service that you're using, you might have an issue. If it's close, and you're not able to make that call, you can always call me. But a lot of people don't check that database. It's not included. People will register their company with the Secretary of State, which is a completely different process, uh, and maybe get a domain name before they really think about, are they going to have any issues with trademarks? So that's my one piece of information I would tell you to take home today. You got the USPTO website earlier. If you Google trademark, US Trademark Office, you'll find it. And search that database before you commit yourself to a new name. The good news about trademarks is that they last forever. Unlike a patent and even a copyright, they have limited terms. Trademark rights last forever as long as you're still using that mark. You think about the Coca-Cola mark. I know people probably historically have believed that the secret recipe for Coke was the most valuable assets, but I would argue now that the Coca-Cola mark is easily the most valuable asset of that company because, I mean, they put it on everything, and so everybody that's using that mark on something is probably paying Coca-Cola a little bit of a royalty to even use that mark. Any questions on trademarks before we move on to copyright? Right?
And you guys can feel free to unmute or put them in the chat.
Mm-hmm. All right. Well, if you think of some, we'll come back to that. We're going to talk about copyright now. So copyright, copyright protects original works that are placed into a medium that can be copied, such as literary works, audiovisual works of art, computer programs can also be subject to copyright, paintings, sound recordings, books. That's what you're generally talking. And for the business owner, some of your website language, your marketing materials, um, some advertisements, and even some trademarks that have a design element. They might have dual protection as a trademark because you're using it with a good or service, and then copyright uh, over the artistic element of that design. So uh, copyright vest with upon creation. We'll talk about that a little bit more, but the term of a copyright is the author's life plus 70 years. So after the author's death, then you had 70 years to that. And in work for hire situations, we're going to talk about a little bit more. Maybe an employer-employee situation is 120 years from creation or 95 years after publication, whichever is shorter. So long-term, not as long as trademark, which lasts forever, but you do have quite a long term. And I want to point out that original does not mean novel. So with the patents, which we're not going to cover today, but patents often will protect inventions only if they're novel. So with originality, it's a little different. I mean, it doesn't have to be novel. So if Aaron and I were in a painting class and we had the same muse in front of us and we painted a picture, and they were almost identical, then we would both own the um, the copyright to the creating the painting that we created because they're original and we placed it on that medium that can be copied. We've painted it. And so again, just original, but not novel. And then also when I say medium, it must be placed into a medium that can be copied. It's very important to understand that ideas and concepts not protectable in any form or fashion. If you have a great idea for a movie or a story and it's all in your head, maybe you even told people about it, but you've never written the story, produced the script, made the video or the movie, then you've never placed it into something that can actually be copied. And so until it is placed in that medium that someone else can copy, um, there's no protection. So ideas, concepts, not protectable. Only once you put in something that someone can actually copy. And it is that copying that constitutes, infringement in a copyright matter. Uh, just remember, I mean, the term of the copyright is pretty long. So most all images that are on the internet are protected by copyright, and you really must get permission to use them, unless there are certain circumstances present. But I have seen a large increase in infringement claims from people just grabbing images here, putting it on their website, putting in a newsletter, etc. Because there's new software available, not really new anymore, but that makes it's easier to identify images. You can search for images, right? And so owners of photographs or drawings can employ usually companies who have that software and are skilled in that searching to look for unauthorized uses of their works. So a lot of people will refer to these people who contact them, they're scams. I mean, generally the claim is valid. It is you used a copyright protected photograph, typically, without permission, and the owner has those rights. Now, the amount of money that they're claiming is usually higher um, than is really reasonable, but the claim itself is valid, and I'm seeing a large increase of these claims in my office. So again, talking about when you get your copyright, the copyright, it vests with the author upon creation. So Aaron and I are in the painting class. The minute we put it into that medium that is copied, that can be copied, we paint that picture, we take the photo, the copyright becomes into existence. So um, no registration is needed to establish the copyright. It does provide some benefits, however, that we'll discuss later, but it vests with the author upon creation. So if you are having people take photos for your business, or you're having, a friend of yours create a logo for you, or just maybe even creating content for your website, you need to make sure that you need to understand that copyright is going to vest with that author, not with you, even if you're paying them to do that, unless you have a written agreement transferring those rights over to you. Um, I, those are usually termed an assignment. It's an assignment. You're assigning those rights over, the copyrights over. So a lot of people, this comes into play when people go to enforce their copyright. Maybe someone's copied their material on their website. I mean, I've had people copy whole pages from websites before, and they don't own it, so it's hard to enforce it because they never got that registration or assignment. I'm sorry, assignment from that author. So that's something important to remember. Copyright can be distinct from the material object, and so the situation I want to point out. I mean, this is not, for example, if any of you grew up and your mother was taking you to a photographer, oftentimes, and before there was a photographer on every corner, like Olin Mills, you would get the photo, you would purchase the photo, but they would retain the copyright. And you often see, if you look at old photos, you see that they had the copyright. It did not give you the permission. They did not give you permission to copy that photograph. So the material object is the photo, but you may not own the copyright. And same thing with the book. You buy the book, and you own that book, but you can't copy it. And again, copyright is just like trademark, it's property. So you can transfer it through an assignment. You can license it, give people permission to use it, or convey it, on your will. You often see relatives of deceased artists, musical artists, bringing lawsuits for infringement or whatnot because those copyrights are lasting 70 years after the life of the author. All right, the rights of here, just kind of a listing of the rights that a copyright conveys to the owner. Copyright is typically described as a bundle of sticks. You have the right to reproduce it, the right to prepare derivative works. And so a derivative work is you make a film from a book or a toy doll or a coloring book from a book. The right to distribute, public performance of the right. And public performing can include broadcasting music in a restaurant. And maybe some of you guys have heard about restaurants getting license requests from some of the musical licensing companies such as BMI because they're broadcasting that music without a license to do so. Public display right and right to perform sound recordings publicly. So those are some of the rights of a copyright owner. Copyright notice, you guys have probably seen this on books and computer software program, but generally it consists of 3 elements: the word copyright, or the C in a circle, the year of first distribution to the public, the name of the owner. All rights reserved can be included also. It's not mandatory, most jurisdiction, but so no registration is needed to use this notice. If you're creating creative works, you're creating the content on your website, put that copyright notice, copyright the year you first distributed it, putting it out there for the public to view, and the name of the owner, hopefully your company. Work made for hire, there are some situations where copyright does not initially vest with the author, and these are when you are an employed and paid to create a product. If I work for Maytag and they pay me to create the manual for the dishwasher, I mean, it's a manual, it's textual written material, that would vest with the employer because of that employment relationship. And you can have a situation where independent contractor, and if it falls within a statutory enumerated category, and you have that written agreement. But the best practice is simply prepare an assignment of copyright to avoid any doubt anytime you're having work created. Joint authors are co-owners, so if there's an intention to merge it into an inseparable work, both are artists. It doesn't have to be equal contribution. Here's another case, just to help you get a feel for that. This case, you had Spawn Comics, which is really highly visual, artistic work. He hired McFarlane, hired Gaiman to write text for the comics, which is kind of like a sub, really not as important typically as these highly visual comics, but there was no written agreement. So Gaiman claimed joint ownership, not just for the story, but for, the characters. And the judge ruled that he was a co-owner and they had a duty to account for the profits from the sale of the work to the co-author. So it can occur without maybe the intention. So just be aware of that. If you're working with someone to create some content. So copyright registration occurs at the Copyright Office. While you don't have, it comes into existence, not necessary to have it. You do have to have a registration. If you ever want to enforce your rights by claiming someone's infringing on your copyright, they've copied your work, you do have to get that copyright filed with the Copyright Office, and that registration gives the federal courts jurisdiction over the claim. It provides evidence of validity. It also allows you to claim statutory damages as opposed to actual damages, where it's if someone's taken your photo and maybe the licensing fee would have been $300 for them to use it. It lets you claim, if the infringement occurs after registration, it lets you claim statutory damage from $750 to $330,000 and up to $150 if it's found to be willful. So it's a much bigger stick to swing in an infringement matter. Uh, it's pretty inexpensive. The current fee to file is $65. There's the website for you. A lot of my clients file their own copyright registrations. The Trade Copyright Office is not checking to see if there's anything similar because it's not about novelty, it's about originality. So once you get the application filled out correctly, they're going to register for the most part. I mentioned there are some situations where you can use people's works. Um, so fair use, you might have heard that term. It is a defense to infringement. I mean, it basically acknowledges that infringement has occurred, but it should be allowed. And so there's a balancing test. A lot of times I have clients who want to use a little bit of this or a little bit of that from a prior artwork, something we know is subject to copyright protection. Um, and there's are certain situations where they can be allowed. So they look at four elements, and it's again a balancing test because attorneys love balancing tests. But they look at four factors. The purpose and character of your use. Is it for teaching? Criticism, of course, newspapers, comments. They can use pieces of copyrighted protected work for comment. Versus, is it commercial or for profit activity? Leans less against fair use. Um, what is the nature of the original work? If it's published, factual, or nonfiction, it's more likely to lean toward fair use if you use a few pieces of that or a portion versus an unpublished or highly creative work or fiction. Again, it's less likely to be considered fair use. The amount of the work used, did you use a paragraph out of a 12-page article, or did you use 2 pages out of a 3-page article? How much have you used? Was it a small quantity or was it a large portion? And then the effect of the market. Sometimes you can't, there's no licensing mechanism. And so you need to use that material and it really has no effect on the market. So that would lean more toward fair use. But if it impairs the market potential, there's a clear licensing mechanism available and you just decided not to pay that fee, then it might lean against fair use. Again, fair use is a defense to infringement. So just to kind of wrap up here, I think we're getting close. Trademarks protect, images, names, slogans that are used to identify the source of the good. They last indefinitely. If you want to get a federal registration, those are some of the costs you might expect. If you use an attorney, copyright protects written, audio, visual work. The term there, life of the author plus 70 years, and less expensive to register, and no renewal fees. I didn't point out that with the trademark registration, once you register, you do have to renew at the 5-year, 10-year, and every 10-year thereafter. So they last forever, but you do have to pay. And are there any questions?
I have a question.
Sure.
Okay, so I'm with Kids on the Block, and I know we've worked with you before on puppets, but
Yes.
we have now written quite a few scripts. And just by the slides, it sounds like we would be allowed to put copyright on there without having to register it. Is that true?
That's right.
We do have other troops, around, even some in Canada, who have reached out and purchased the scripts from us. So we don't have to register anything. We can just put that copyright on there and say, copywritten Kentucky Kids on the Block.
You sure can. No, I would ask, were they employees who created the work, and was that part of their job description?
Yes. So we usually have either interns that work with us, help us work on the scripts, but we also pull in like ideas from community members. Like we have script committee, it's Kids on the Block script committee that we use, but the actual writing is either an employee or an intern that we have.
Okay, so in that intern situation, it's less clear if it's an employee. So before they leave, I would have them just do a simple assignment. I'm assigning all rights over to Kids on the Block. Uh, as far as registering those scripts, the benefit is if anyone starts using it without your permission, you'll be in a better position to have statutory damages and be ready to file suit if you need to. Again, you're in a stronger position to enforce your rights if the infringement occurs after registration. Registration can occur after infringement, but
Okay.
you're just in a stronger position. It's pretty inexpensive to register. I mean, it's $65 filing fee. I'm not sure how many scripts you have, but probably, I'm not saying you have to register everything, but if you have one that you're sending out to other people and you have people who are paying you for it already, you might consider an investment in registering that script.
Okay. And so is that's just something we can go online and register the piece? Like how does that?
Well, the Copyright Office website, it is all electronic. So
Okay.
yes, you can. And you can look at it, Amanda, and see if you think you feel confident with it. I have clients who do it, and I have clients who say, I don't want to do it. So if you hired me to do it, I usually charge around $600. It's just a couple of hours of work for me. And so, but I do have clients that do register themselves. In this situation, it might be a little tricky only because you've got potentially interns and, you're looking at that issue, but you can certainly look at it and see what you find.
Okay. And then I have another question too. And well, I'll let somebody else ask a question first if they want to ask before I ask the other one.
Okay.
Anybody else has any more?
Looks like you got the floor, Amanda.
Okay. So we are currently working on a new project. We're developing new songs to go along with each of our scripts that we present on. We've already gotten our first one. So by the way it sounds, so we've got a couple of Western professors they've written the songs and then we're getting children to sing in them. So the copyright would that belong to the people who wrote the song and are recording it? Does that belong to the kids that are singing in it? How would that work? Does that belong to us because we're paying them for the service?
Only if you get that assignment of rights. I mean, that's a situation where you should clarify if you're paying them to create it, they should be assigning those rights over to you.
Okay.
I mean, but if you don't have that writing, it doesn't transfer.
Okay.
I mean,
so they need to assign the rights.
The law is very protective of artists, and so you got to have that assignment.
Okay.
If you have the assignments, even from the children who you're getting the agreement to sing and record, then it's easy.
Yeah.
Who owns it? If you don't get assignments, then situation would be it could be that the professor owns, the music, the score. I mean, audio visual. I mean, musical recording has several components. You got the music, the melody, who wrote the words. I mean, maybe the same professor. Then you got the audio recording where the children are involved also. So both the professor and the children might be involved in that. But unless you're getting that assignment, Kids on the Block is not going to be the owner.
Right. Okay.
Yeah.
I did have like a permission slip that parents had to sign, and on that I did put on there for the kids that were singing that Kids on the Block will own the rights, and they signed that. Does that count toward, or is it more of a legal document we would have to get signed?
No, well, maybe. I mean, it would be evidence of that intention. I'd have to kind of look at it, but I mean that's definitely better than nothing. So, yeah.
Okay. And then I had one last question for you. Sorry.
No, you're
My
fine.
last question question is, so the National Kids on the Block shut down maybe like 9 years ago. We have like the songs that they created. We've got 2 songs that they created that we still use in our program. But we like those songs, but we want more updated music. Is that something that we can do? Is have them re-recorded and legally, is that something we can do? Have kids sing the same lyrics, re-record it, change the music behind it, or do you think that still falls under copyright even though the office is shut down?
Well, the copyright is still in existence. I mean, I think the question is who owns it, right? If you don't have a purchaser for that company, I mean, did they even take steps to get the owners? I mean, you just don't know who the owners are. So you are swimming in the dark a little bit there because you just don't. The company's closed. There's probably no way to find if they got the necessary assignments. Who really owned it to first? And this company's now defunct. No one actually picked up their assets. Did anyone purchase? It doesn't seem like it. So in that situation, I'm not saying that someone couldn't show up and say, hey, my dad wrote that song and he never assigned it to the national company and he's the copyright owner. And you might have a situation, but there's no obvious issues that you see, right? So just being aware that that's a risk. But if you took the words, changed the music, right? I mean, so you're kind of moving the potential music copyright owner out of the field of question. And now you all got is all you have is the lyrics. So then you could claim ownership to the lyrics, to the new music, if it was original, right? And you got the rights to that. And then the recording, again, you would be maybe a joint owner. I mean, you don't know who wrote the lyrics, but you would have some rights to that recording.
Okay.
As long as, you took necessary steps to make sure you did.
Okay.
Does that make sense? Or
yeah, I think so. So I think it kind of falls into like where we were when we started redeveloping the puppets. As long as we have reached out and tried to figure this out, and no one's responding back.
That's right.
Make the puppets, so it's kind of the same thing with the lyrics or the music.
Yes.
Okay.
I can't tell you for sure that somebody's not going to show up, but generally you've made good efforts, and I would record your efforts to kind of make contact. And I think that's what we talked about. Now that I forgot that we'd had that situation, but no one's there, so I don't know if I wouldn't use it. Just be aware that you might just share if you get any money from it. So
right. Yeah. I don't, it kind of like what we've done with the scripts. If another troop reaches out and it's a script that we've not done anything to, we just let them have it. But if it's something that we've, completely written, then we sell it. So it'd probably be the same kind of thing. If another troop needed the song because we didn't actually write that song ourselves, I think we could probably give that song. But now the new music that we're having, that we're writing and that we're producing and all, right. I feel like we could sell that with the, the recording studio's permission, of course, because it's there.
Right.
Okay.
I think you're right.
Good.
Yeah.
All right. That answers my question.
Okay. Oh, good. Anyone
that was
else?
A great question. Oh, sorry. We have about 5 minutes left, so this will be the last call for questions if anyone has any.
Please don't hesitate to interrupt if we don't have any questions, but I did want to just comment on AI before we log off here. I didn't talk about that, but of course, AI generated content raises lots of issues on copyright regarding authorship, ownership, infringement. So the courts, the Copyright Office, there's lots of cases. Every week there's a new case with the courts on copyrights and AI, but generally AI is not a person. So under the Copyright Act, they're not they're not an author because they're not. You have to be a person to be an author, and so no one, who owns the copyrights to AI generated material. It's not clear at all right now. It doesn't look like anyone does. And the other issue is that AI models are trained on copyrighted material because they're fed all these materials that are subject to copyright protection, books and articles, and without authorization. And is that infringement? That's the other issues that's kind of working its way through the courts. So I don't have answers to those questions. I just wanted to point them out.
Perfect. Thank you so much, Laura. We
Yeah.
got a lot of really good information on keeping your business safe, keeping your intellectual property safe, and truly want to thank you for presenting this to
Oh,
our
you're welcome. You're welcome. I enjoyed it.
members.
Yeah.
As a reminder, we will be sending this out to the membership. So thank you all who were on the live with us participating. If you want to watch it again, it was a lot of really great information. It is going to be up on our website and our social channels by the end of the day. And if there are no more questions, we're going to go ahead and end the webinar. And I hope everyone has a great Tuesday.
All right. Thanks for having me, Erin.
Thanks,
Thank
Laura.
you.
All right. You're welcome.